Students for Fair Admissions. This landmark Supreme Court decision changed the college admissions landscape in ways institutions are only beginning to understand. Please welcome the Honorable Judge Stephen Menashe of the United States Court of Appeals for the Second Circuit, who will lead this conversation with our panel.
Thank you very much. Angela, welcome to the, thank you. Thank you and welcome to the afternoon panel. Oh, is it not? Is this, oh, I think it's on. Oh, maybe I should just be closer to it. Is that better? Okay. So as you know, in Students for Fair Admissions versus Harvard, the Supreme Court held that the use of race in admissions at Harvard and UNC lacked a sufficiently measurable objective, a meaningful endpoint, used race in a negative manner, and amounted to racial stereotyping, and for those reasons could not be reconciled with the guarantees of the Equal Protection Clause. The court said the student must be treated based on his or her experience as an individual, not on the basis of race. But at the same time, we've seen recently the Supreme Court deny review in a case called Coalition for TJ versus Fairfax County School Board about the extent to which schools might use facially race-neutral policies to achieve a racial balance. And Justice Alito, in his dissent from denial, called it a blueprint for evading SFFA. So it's uncertain what impact the case will have on the legal landscape and on policies at institutions of higher education and secondary education. And so to puzzle through these questions, we have a distinguished panel of experts on these topics, and I will introduce them in the order in which they will be speaking. So first we'll hear from Cameron Norris, who is a partner at Consovoy McCarthy. He's argued twice at the U.S. Supreme Court, including on behalf of Students for Fair Admission in the Harvard case. He's a former law clerk to Justice Thomas on the U.S. Supreme Court, to Justice Pryor on the 11th Circuit, and to Judge Pryor on the 11th Circuit, and to Judge Henderson on the D.C. Circuit. Next, we'll hear from Andre Cummings, who is Dean and Professor of Law at Widener University Commonwealth Law School. He previously served as the Charles Baum Distinguished Professor of Law at the University of Arkansas at Little Rock's William H. Bowen School of Law, where he was the co-director and co-founder of the Center for Racial Justice and Criminal Justice Reform, and served on the University Diversity Council and the Chancellor's Race and Ethnicity Advisory Committee. Previously, he taught at West Virginia College of Law and clerked for the Associate Chief Justice Durham of the Utah Supreme Court and Judge Hatchett of the 11th Circuit. Next, we'll hear from Richard Kallenberg, who's the Director of Housing Policy and the American Identity Project at the Progressive Policy Institute. He also serves on the advisory boards of the Pell Institute and the Albert Shanker Institute, and as a professorial lecturer at George Washington University's Trachtenberg School of Public Policy and Public Administration. He's the author-editor of 18 books, and his scholarship focuses on education, civil rights, and equal opportunity, including class-based affirmative action and higher education admissions. Next, Todd Clark is the Dean of Widener University Delaware Law School. He previously served as Professor of Law at the St. Thomas University Benjamin Crump College of Law, a Professor of Law at North Carolina Central University School of Law, and a lecturer at West Virginia University College of Law. He and Dean Cummings co-authored a book entitled Corporate Justice that explores issues of social justice, corporate power, and diversity. And our final speaker is Allison Soman, who is a senior legal fellow at the Pacific Legal Foundation, where she's part of the constitutional scholarship team and focuses on equality, opportunity, and separation of powers. She was part of the team that represented the Coalition for TJ in its challenge to the Fairfax County School Board's admissions policy. Before joining the Pacific Legal Foundation, Allison worked as a special assistant and counsel to Gail Harriet, a commissioner on the U.S. Commission on Civil Rights, and a Koch associate at the National Federation for Independent Business Legal Foundation. So with that, let's start with Cameron Norris.
Thank you, Judge Menashe. Good to be here. I am not yet tired of talking about the case that I won at the Supreme Court, so this is another good opportunity. But in truth, I deserve very little credit for that. The credit, in large part, should go to the late Will Consovoy, who is the founding partner of our law firm. The only reason I argued the case is because he was sick with brain cancer, did not get to see it through, but the whole case was his strategy, his idea, his execution, his arguments, and he really deserves all the credit. So I'm just going to remind you a little bit about what the opinion does and does not say, and then we can talk about what that means for the future. So the question presented that we wrote on the first page of the cert petition was whether the Supreme Court should overrule its decision in Grutter versus Bollinger. And interestingly enough, the word overrule does not appear in the majority opinion. There's no clear explicit statement that Grutter is overruled. So that is strange. That is what we briefed and what we argued. We were a little surprised to see that. But I would submit that there's no real difference in what the opinion accomplishes. So if you thought Grutter is still good law that universities could use to consider race in the admissions process, 0 universities are taking up that option today. No one is openly saying that they are going to continue using race in the admissions process at a private or a public university, with the exception of the U.S. military academies, which have a footnote that addresses them in the opinion. But no one else is openly using race after the opinion. And why is that? Well, I think the reasoning in the Chief Justice's majority opinion is an incredibly broad and powerful indictment of the use of race at all in American society to classify citizens. So what does the opinion say? It says that race as a matter of law can never be a negative for someone. An individual's skin color can never be used against them. It is unavoidably used against them when it's used for someone else in a zero-sum process. That is quite broad reasoning. Of course, it has applications not just to admissions, but employment and other endeavors where there are a limited number of seats in question. It also says that the use of race in admissions involves stereotyping, and not just Harvard and UNC, who were making assumptions about what people might think and believe based on their skin color, but it's stereotyping whenever you use race qua race is the phrase that the Chief Justice uses. So if you give someone a preference because of their race in a vacuum, you are necessarily assuming that their race tells you something important about that person. That is the illegal stereotyping. That applies to every use of race in a vacuum, the checkbox that we talked about at the argument. The opinion also says that the racial categories that the federal government requires everyone to use are utterly arbitrary and incoherent, that they don't actually say anything useful about the world, and so if you're using them, then there is a fundamental mismatch between whatever your goal is and your use of race, because those categories were made up for bureaucratic reasons that don't have any actual public policy value, and they don't accurately describe either how people see themselves or how cultures relate to each other. And the opinion also says about the educational benefits of student body diversity. That was the interest recognized in Grutter. The opinion is brutal to that stated interest, and so you could question whether how much is left of Grutter after the opinion. It says that those interests, those educational benefits are amorphous, they're subjective, they are impossible for courts to assess whether they're present or absent. The only way to really get there on strict scrutiny is to give deference to the universities that these things actually exist and can be measured, and that's not something that we do for race under strict scrutiny. And if they are measurable, it's only because what universities are measuring is not educational benefits, but just whether they're actually hitting specific racial numbers. But while that is measurable and that is what universities were doing, that's long been considered racial balancing, which is unconstitutional on its face under a series of Supreme Court cases. That's the broad reasoning in the opinion. The opinion also concludes with, I think, what everyone expected would be the next fight, which is, are there ways to evade the opinions holding that you cannot consider race in admissions? The opinion, really for the first time in a Supreme Court opinion, says states cannot consider, have facially race-neutral policies that are intended to benefit certain racial minority groups. That has actually never been held by the Supreme Court until Harvard. The Supreme Court had said you can't have facially neutral policies that intend to harm racial minorities, but they never said that about policies that intend to benefit racial minorities. That's now law. The Chief Justice gives examples about essays and other ways that universities might try to evade, actually cites my portion of the oral argument on what universities can do when they consider essays, and says, basically what I said to the court was, you can consider someone's ethnic, cultural background as it affects that person as an individual as a reason to prioritize or preference that individual, but you would have to give equal preference to someone of a different race who wrote the exact same essay. And that is the part that gets cited in the majority opinion. I think that's an accurate statement of the law and what universities should be doing with these essays. And so the last thing is, you may have seen in the news that we're starting to get the admissions numbers for the first class admitted after Harvard. Those are only coming out because universities are required to publish that information or to give that information to the federal government and to the Department of Education. You're starting to see those numbers. We don't have them all yet. I think it's premature to make any conclusions about them quite yet. I think we need to have a full national picture of schools and their peers. And I will say, though, that if those numbers are not moving very much from where they were before Harvard, it raises interesting questions about sort of enforcement actions and follow-on litigation, because as far as we know, universities are not taking up the alternatives that we proposed in the litigation, like dramatically increasing socioeconomic preferences or ending legacy preferences, things that we mentioned in the Harvard case. And so there'll be a lot of data to consume here in the coming months, and it's something we're looking at very carefully.
Thanks very much. Can I ask a question about this relationship between SFFA and Grutter, which is that SFFA, as you said, it purports to be an application of Grutter, right? It says we're just applying the criteria we laid down in Grutter before. Fine, diversity is a compelling interest, but you need to measure it somehow, and they haven't shown measurements. And this stuff about using race as a negative, that was in Grutter. But you're right, the way the Chief Justice talks about it is to say, well, if it's a zero-sum game, any preference for one person is a negative for somebody else. And if you thought that, you probably wouldn't have written Grutter the way you did to say it could be a plus factor. So your position is there, I guess I put it this way, is there a way to read SFFA as an application and fulfillment of Grutter, or do you think that it's just inconsistent?
No, I think that may explain why the word overrule is not in there, in that the Chief Justice was saying that the legal principles in Grutter and Fisher and even Justice Powell's opinion in Bakke were correct. They just weren't really being applied in a straightforward fashion. And so if those principles had been applied correctly, would Michigan Law School have won Grutter? Probably not. But the principles didn't need to change. They just needed to be applied. And they finally did so against Harvard and UNC.
Okay, thanks very much. Dean Cummings.
First of all, I'm delighted to be here. I want to thank the Federalist Society, Paul Zimmerman for putting the panel together, as well as my fellow panelists and Judge Menashe for moderating us today. As a dean of a law school, I think really hard about these issues of admissions and race and consideration and the diversity rationale. And I was bemused when I saw all of the death knell pronouncements and the dancing on the grave of affirmative action, because I read the SFFA case very differently than those who either celebrated or bemoaned the death of affirmative action for the following two reasons. First, as Mr. Norris indicated, there is no explicit overruling of Grutter or Bakke or Fisher in this case. The case simply found that UNC and Harvard did not comply with the law as laid out in those cases. And secondly, this Roberts Court is no respecter of precedent. It is not shy about overturning or rejecting precedent, and didn't do so here. And so what does that mean as far as affirmative action is concerned, and whether or not it's alive and well in university admissions? I recommend an article by Stephen Ramirez, who's a law professor at Loyola of Chicago and the Seattle Law Review, where he talks about affirmative action and cognitive diversity and how this case can actually be read to support cognitive diversity in the classroom. So first of all, Justice Roberts provides a roadmap explicitly stating the following in connection with whether or not race or can be considered, or I agree with Mr. Norris that the check the box What is your race can no longer, it can no longer be used by university or law school admissions processes. Race qua race, as he states, is unconstitutional under the Equal Protection Clause. But this is what Justice Roberts says in the case. Nothing in this opinion should be construed as prohibiting universities from considering an application's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. He then continues to say, a benefit to a student who overcame racial discrimination, for example, must be tied to that student's courage and determination, or a benefit to a student whose heritage or culture motivated him or her to assume a leadership role or attain a particular goal must be tied to that student's unique ability to contribute to the university. In other words, the student must be treated based on his or her experiences as an individual, not on the basis of race. A more creative university than Harvard or UNC could likely figure out how to admit a very diverse class of students based on the qualifications that Justice Roberts indicates here. So here's a few thoughts about how this case came out and what its impact is. Mr. Norris mentions that there's a lot of data that will be coming out. The first snippet of data is that out of the five of the 6 top law schools, their minority enrollment did not decrease since SFFA. Does that mean they're not complying with the law in SFFA, or have they been more creative than Harvard and UNC were in assembling a diverse class of students? And let me say, as a dean of a law school, that for us, it is very important that we have a group of diverse students to fill our classrooms. It's a goal that's important. It's something that the Grutter and Bakke and Fisher cases extol as virtue, this diversity rationale. The primary difference as I read the case is that checking a box based on race does not equal diversity or constitutional diversity. It must be tied into the mission of the university or the experiences of the individual. And I agree with Mr. Norris in that if a white student expresses having a racially discriminatory experience as a black or brown student would, that would be considered equally when considering seating a diverse class of students that have overcome, in Justice Roberts' word, racial discrimination or inspiration or otherwise. The last thing that I'll mention here, and I look forward to a robust debate as we go forward, is that as I've read thousands of personal statements historically, what I believe a creative school could do is remove the check the box race from their applications, could in fact encourage folks to talk about how they've overcome obstacles in their life, including, in Justice Roberts' words, racial discrimination or other instances where they've had to overcome difficulties in their life. And that will allow a robust, diverse class of students, both racially, socioeconomically, talking rural diversity, Appalachian diversity, first generation diversity, populations that have been discriminated against, diversity, communities of color, so long as it's based on an individual's experience with overcoming those obstacles. And so an admissions committee that's looking for a diverse class of students will be looking for personal statements that indicate how folks have experienced life. And as I mentioned, as someone that's read thousands of personal statements, I'm sure you all would agree, some people have just overcome incredible obstacles of all races. And those are the folks that we want in law school, right? We want them seated in our classes. We want them sharing their experiences with each other. We want them graduating and representing populations that have been harmed or discriminated against historically. And that ultimately is the goal. And I think with those goals in mind, creative admissions committees can enroll robust, diverse classes that bring global diversity into the environment of the law school and enriches everyone's education. Thank you.
Thanks very much. Can I ask, so what would be happening in that scenario is not, like you wouldn't need the diversity rationale because what you're describing is not discriminating on the basis of race. You're saying if you do a holistic view of each individual based on their personal statement, it's not racial discrimination. And the Chief Justice, with the caveat that it must genuinely be based on that person's character, says it's okay, right? So just to get at the connection between the 2 points you made, one, you're saying the diversity rationale survives in some sense, and two, that you could do admissions based on personal statements. But if that's genuinely not race-based, then you wouldn't need a special justification for it, right?
I'm not sure I'm
Like, so
understanding this. Harris, you're
admissions
splitting?
based on the personal statements is not a racial classification or a
Correct.
checkbox, right?
Correct.
So those are two separate ideas. One is that maybe there's some way to operationalize the diversity rationale still. But two, maybe, what the Chief Justice suggests about focusing on personal statements might be a way that you don't need to have a special exemption from the Equal Protection Clause or other restrictions.
Yeah, that's a good point. And I think one of the things that is critical for us as leaders of law schools is that we're looking for opportunities to enroll classes of students that have been historically harmed or shut out, and reading about those experiences in their personal statements, whether or not they're talking about their race, which they're completely able to do as far as consideration is concerned in this case, would indicate to us that these are folks that we want seated in our classroom, and that would enrich the conversations and would enrich the profession.
All right, thank you very much. Professor Kallenberg.
Thank you. And thank you all for being here. It's wonderful to be with the Federalist Society. So let me start off by being agreeable. I'm going to agree with Cam that racial preferences are a huge problem in American society, and I'm going to agree with Andre that racial diversity is a good thing. I think that's where the American public is, and I feel like I'm situated not only in the physical center, but the ideological center of this discussion, which is where I like to be. I'm a center-left person who visits a lot of college campuses where I'm the closest thing to a conservative in those environments. And so this is, I'm really looking forward to this discussion where we do have genuine diversity of views. So I've long advocated kind of a third way on affirmative action preferences based on socioeconomic disadvantage rather than race. I've long thought that basically universities were using race as a proxy for disadvantage, and why not go after the actual condition of disadvantage that tells us a lot about the potential and true merit of an individual applicant. So in the SFFA case, I testified for the plaintiffs as an expert witness, and the empirical evidence, I think, was clear that if an institution used race-neutral strategies, such as providing a leg up to economically disadvantaged students, or using a percentage plan like Governor Bush did at the University of Texas, where the top 10% of students were admitted from every high school, that you could achieve high levels of racial diversity. And I worked with Professor Peter Arcidiacono, the other expert witness in the case, to model what would happen if Harvard and University of North Carolina used race-neutral alternatives and eliminated some of the preferences for very advantaged people, so things like legacy preferences. And it was clear that Harvard and UNC could achieve robust levels of racial diversity and much more socioeconomic diversity if they used these approaches. So we basically drew them a detailed roadmap of what they could do if they lost in these cases. So I've been eagerly awaiting the data from universities that's starting to trickle out now, and some of you may have seen Harvard announced its information earlier today. I have a book coming out on the topic of affirmative action, and right now there's a placeholder in the bound galleys, results from 2024. And so, I've been really interested in watching what would happen, and in the last couple of weeks, I've been fascinated to see what has happened. So most of the headlines in the press have been about institutions where they have seen declines in racial diversity. So these are places like MIT and Amherst and Brown and Tufts and the University of North Carolina. I think this is deeply unfortunate. I think that racial diversity brings strong benefits on campus, and that universities can achieve racial diversity within the constraints of the law. So when MIT says that it's entirely the Supreme Court's fault that the demographics of this institution changed, I think MIT is letting themselves off the hook. I've been very pleased that at many universities, racial diversity has survived. And so it's early on, but I would say most of the institutions, and I'm glad to hear your 5 of 6 leading law schools data on racial diversity. Most universities have been able to preserve diversity. So Yale, Princeton, UPenn, Duke, Emory, Bates, Caltech, Williams, and then today Harvard, all have done quite well on racial diversity. Now, the million-dollar question, of course, is how are they doing it? Are they doing it legally, or are they not doing it in ways unintended by the Supreme Court? And I think those are the two major alternatives. They can use authentic race-neutral alternatives like Governor Bush's top 10% plan, or socioeconomic preferences that the Supreme Court championed in the SFFA decision. Justice Gorsuch, for example, talked about the modeling that showed what Harvard could do if it used race-neutral alternatives. And so that's one alternative. The other is to cheat. And I think I'm probably going to disagree a little bit with Andre. I read the essay provision in the Supreme Court's decision as extremely limited. The dissent certainly thought it was very, very limited. They said the decision was disastrous. They said that the essay provision was lipstick on a pig. So they didn't put a lot of stock in the idea that universities could simply comply with the decision very easily by just looking at student essays systematically. So the question becomes, which of these two practices are they engaging in? I agree with Cam that it's too early to know for sure. I would look at 2 pieces of data to ask whether they're cheating or whether they're using authentic race-neutral alternatives. The first is to what degree they have announced new plans to increase racial diversity in legitimate ways. So Duke University, for example, which did see good racial numbers, it significantly expanded its financial aid, and it ramped up recruitment quite a bit. The second provision I would look at is whether they actually have a more socioeconomically diverse class, and which would be some evidence of using race-neutral alternatives. And in this case, again, Duke doubled its percentage of students eligible for Pell Grants in the last 2 years. So in Duke's case, I think maybe they are doing some things on the up and up. By contrast, if a university did not adopt any new race-neutral alternatives and did not see a change in socioeconomic diversity, I think that raises significant eyebrows. So I'm going to conclude with a plea for this audience at the Federalist Society. I think conservatives should go after cheating and not after authentic race-neutral alternatives. And to be sure, there are some who've argued for straight-out cheating. Richard Rothstein wrote a piece in The Atlantic where he said universities should just defy the Supreme Court. And so there is that alternative. Unfortunately, in my view, there's been a wrong-headed effort to go after authentic race-neutral alternatives that's also been launched. And And you'll hear from Allison in a minute, and she will certainly have a different view of this issue. But here is my take. The Thomas Jefferson High School, which is, as many of you know, is a selective magnet up in Virginia, adopted a percentage plan and socioeconomic preferences. So exactly what conservatives have long argued that institutions should do rather than use racial preferences. Now, the lower court sided with the plaintiffs and claimed that this was proxy discrimination. But the Fourth Circuit reversed, and I think there's one judge who had it right when he said, this is essentially a judicial bait and switch. If institutions are told to use authentic race-neutral alternatives and now will be called out for it. I'm pleased that the Supreme Court declined to take the TJ case, and I think it's very telling that while 2 conservatives dissented from the cert petition, 4 of 6 conservatives did not join that opinion. There are more cases coming. We're going to have the Boston Latin case considered soon. But my hope is that the Supreme Court and the conservative movement more generally focuses on the actual cheating that may well be happening at many institutions. So in closing, I will say that for years, my liberal friends really kind of blatantly defied public opinion. And they backed a divisive and deeply unpopular policy of racial preferences. And I would urge you not to make the same mistake in the opposite direction. Because going after authentic race-neutral alternatives makes it look like your enemy is racial diversity rather than racial preferences. And if the movement is seen that way, then you will lose the American public. Thank you.
Thanks very much, Professor Kallenberg. Can I ask this? So you talk about authentic race-neutral alternatives, but you also said that MIT is letting itself off the hook by blaming the Supreme Court because they could still achieve diversity with those alternatives. But if you're applying authentic racial alternatives, aren't there going to be some cases where you don't achieve the same levels of diversity you might otherwise do? Like if you're rejiggering the alternatives in order to get a demographic balance that you want, then it's not really an alternative, right? I mean,
Yeah.
Wouldn't you see at least a mix of maybe you'll achieve diversity anyway, but some schools wouldn't necessarily if they're authentically pursuing socioeconomic diversity as opposed to racial?
Yeah. So I think there will be variation. And in the case of MIT, it's obviously a STEM school. That's a special case. But they saw a drop in the percentage of black students from 15% to 5%. And using race-neutral alternatives, I haven't I haven't crunched the numbers there. These are not publicly available data. But there are not other institutions that have tried authentic race-neutral alternatives that have failed so miserably as MIT. So I don't mean to say MIT should expect to have precisely the same level of racial diversity as it did using racial preferences. By definition, racial preferences are the most efficient and direct way to get a certain racial result. But I'm reacting to the idea that MIT suggested this is out of our hands. There's nothing we can do, and I think that's wrong. If MIT aggressively reached out to more socioeconomically disadvantaged students, they don't have to live with a highly segregated racial environment.
Okay, thank you very much. Dean Clark.
Thank you very much. So first I want to say thank you for the invitation. It is always a wonderful time to come back and congregate and have a conversation with the friends that I've generated through the Federalist Society. And it's actually fun for me to come back and see some faces that I recognize and engage with some people that are really now friends for me. And because of that, I want to feel very comfortable in this space. And if you will allow me just an opportunity to be vulnerable for a second as a black law dean after the SFFA case was decided. I've been a professor for almost 20 years. I'd like to think that I'm a good professor. I've been nominated for Professor of the Year. Not nominated, I've won it 3 or 4 times, and I've done well in the classroom. And when that decision came out, I was really concerned to the extent that I thought that it would jeopardize my ability to engage with a group of students that shared different viewpoints and different perspectives. And I was really concerned that the decision might have the impact of eliminating racial diversity in law school classrooms, or limiting that diversity. And I've been in those types of environments, and the classroom experience wasn't as enriching, it wasn't as challenging. And I will share this quick point, which is some of the best classes that I've ever had is when I had really strong liberals and really strong conservatives, and I would walk into a classroom with a little bit of gasoline and a match, and I'd throw it out, and it would burn. Just like much of the discussion that the Federalist Society tries to facilitate, where you have these panels and presentations where you have this beautiful, balanced viewpoint set in really intelligent people, and it makes you say, you know what, let me figure out the sort of the logic, the why, and understand this person. And those were great classroom experiences, and I was fearful that that would be jeopardized. So I took an opportunity to go back and read the opinion, and I did invite my buddy Dean Cummings over here, so he took some of the things that I was going to say. So I won't duplicate the will and repeat Justice Roberts' opinion, because I think he did a wonderful job of that. But if you walk away from that opinion, there are two things that are true about that opinion. It did not eliminate affirmative action policies, and the second thing that it did is it didn't eliminate diversity. And I think that those are two very true perspectives. And Justice Roberts makes it very clear about how law schools can go about acquiring and obtaining diversity in the law school classroom. And I think that what it does is it enhances the ability and the process for effectuating fair diversity in the classroom and eliminating this idea of check the box, where you're really looking at the narrative and the experiences of these students, of all students, and then asking, how does this enhance, or how does this enable the student to contribute more positively to the law school community, which I do think makes the evaluation much more fair and much more efficient to accomplish this important goal of diversity, as Mr. Kahlenberg mentioned. What I think that is really interesting is, while we don't have data just yet about how law schools across the country have done with respect to their diversity percentages after SFFA, what we do know is that after that case, there was a pretty substantial increase in the number of applications from minority groups. African American applications increased about 7%, and you saw the same for Hispanics. And so what I can tell you is at Delaware Law School, we did exactly what Dean Cummings mentioned when the case came out. We eliminated the check the box, so we have no idea the racial composition of our students. It did allow us to pay greater attention and really enhance our process to look even more closely at the individuals that are applying to our law school. And one of my proudest accomplishments is to say that we had the greatest level of diversity in the history of our law school after SFFA. And I thought to myself, this guy, Justice Roberts, is a genius. His primary objective was to increase diversity, but he wanted to do it in a way where people were more thoughtful and more deliberate and focused on the story. And as a law professor, I can appreciate that. It's not just about the conclusion and the outcome. It's about the narrative that you tell to connect those two things. And that's exactly what I teach in my classroom. I do have one of the challenges, or one of the concerns that I have as a dean, and when we engage in this discussion, Cameron always makes some really thoughtful points, but I do disagree with this idea that if the numbers don't change, that if we see an increase in diversity, then that means something is run afoul, and that there are certain preferences that we should focus on other than certain preferences on which we should focus. From Justice Roberts' opinion, the story is part of the preference. And I think it's important to note that the story that young people tell about why they belong in a particular place and how it enhances their capacity to be in a place, that is an important consideration as indicated by Justice Roberts. So I think that if you walk away from this and you believe that if the numbers change, that you should expect that the diversity numbers decrease. If anything, the way that I view it is diversity numbers should increase if individuals that come from marginalized communities, if they have difficult lives and they're able to articulate those stories, I want people in my classroom that have been through something because they can share something. They add something to the classroom experience that gives them a unique perspective in how they think about the law, how they contort it, how they shape it, and how they advance their ideology. So with that said, I'm going to stop, and thank you very much for your time.
Thanks. And so you're saying the way that you achieve the diverse class is by focusing intently on the quality of the essays. Maybe it's too soon to tell, but has the explosion that you precipitate in the classroom, is it different? Like, do you see the quality of the students different in that kind of an admissions approach?
So actually, that's actually a really good question. What I can tell you about this class that we admitted this year, it is not only is it the most diverse class, but it is the most, in terms of academic accomplishments, it is the strongest class that we've had in at least 5 or 7 years. Our LSAT profile has increased. In fact, we almost gained an additional point at our top quartile, and our LSAT medium was very close to getting to the next point as well. Overall, our GPAs had increased. And so what we're seeing from this is this more holistic review. Justice Roberts helped enhance our admissions process. And I'm hopeful that next year we'll even have more diversity. And in addition to that, we'll have a stronger profile of students. You know, I don't want to know, there's no way for me as the dean or in admissions to see anything dealing with the students' racial compositions, but we do have the stories, and I think that has enabled us to take a better look and better evaluate. I will tell you this, and this is something that we have not discussed, is that sometimes you could get a student that has, let's say, a 157 LSAT score, which is not at the highest end, probably slightly above average, and they have a 3.0 GPA, and at a lot of law schools, that would be a student that you would admit. But there's a story that may be missing from that student. Sometimes having a better understanding of what that student went through, what they've gone through, what they can contribute to the classroom gives you a better ability to assess whether that student is going to be successful. I've had a number of students that we've admitted with higher LSAT scores that have failed out because they just didn't have the integrity or the fortitude to make it through law school. And I think paying a bit more attention to people's experiences before they get to the law school will help us be more efficient. Hopefully it will help me with my bar passage rate because I will have students that are going to do everything that I'm telling them that they must do at Delaware Law School.
So in the SFFA case, a lot of universities filed these briefs saying that if we can't explicitly consider race, then our diversity rates are going to go way down. We can't achieve a class that is demographically diverse. So is your conclusion that they were all just wrong about that?
You know, I'll tell you this, and it's a great question, and what I would say is that I think that those initial responses were reactionary, and like, remember when I started this off, I told you that I want to be vulnerable and share, and I'll talk to you a little bit about my fear. I think that some of those responses were about fear. I think some of those responses were comparing the SFFA case to what happened after many states started enacting affirmative action bans. We did see a precipitous decline in the amount of diversity at law schools in states that adopted the affirmative action bans, but those were complete prohibitions. What Justice Roberts did, this was not a prohibition, it was a way to enhance your ability to discern who are the best people to put in your classroom. So I think that part of it is time has told us a little bit different story, and I think it's given us an opportunity to learn. I think that Justice Roberts wisely put a blueprint into the opinion so that we can think critically about how to accomplish fair and reasonable diversity.
Thanks very much. Ms. Soman.
Thank you for that kind introduction, and thank you to the Defense of Freedom Institute and the Federalist Society for inviting me here today. As Mr. Norris has already discussed, the Students for Fair Admissions decision was an important victory for the principle that individuals should be treated as individuals and not on the basis of their membership in racial groups. I'm not tired of talking about this important victory for this important principle either. But our school is actually going to follow it. Unfortunately, as a few of my co-panelists have already alluded to, the early evidence suggests that they won't. How do we think that they're going to cheat? By proxy discrimination. Mr. Kallenberg has already alluded to this possibility, but let me just put a little bit more flesh on the bones of what we say when we talk about proxy discrimination. Basically, the concept refers to the use of a proxy for race to achieve a racial result. From earlier in our nation's history, you may remember examples. One of the earliest ones that I can think of on the books is Yik Wo, a case involving the facially race-neutral regulation of laundries in San Francisco, struck down by the Supreme Court in spite of its facial neutrality. As the court then said, though the law itself be fair on its face and impartial in appearance, yet if it is applied and administered by public authority with an evil eye and an unequal hand, so as practically to make unjust and illegal discriminations between persons in similar circumstances, the denial of equal justice is still within the prohibition of the Constitution. Other unfortunate examples from earlier nation's history: the grandfather clause, the literacy test, the poll tax, now prohibited by constitutional amendment. Eventually, the Supreme Court has made clear that using each of these proxies for race is just as illegal as using race itself would be. Today, a 1978 case on this topic, Arlington Heights, which was about a residential real estate developer who is alleged to be using proxies for race to achieve racially discriminatory results, sets forth the framework that can be used, a multi-factor balancing test for identifying when a decision maker is using race is using other traits as proxies for race to achieve racial results. So what does more contemporary proxy race discrimination look like? Allow me to tell you about three Pacific Legal Foundation cases in this area. First one, Coalition for TJ versus Fairfax County School Board, which you've already heard a little bit about. Thomas Jefferson High School for Science and Technology is a magnet school in Alexandria, Virginia, that was at one point rated the #1 high school in the United States, according to US News and World Report. It specializes in math and science education for gifted students. In fall 2020, in response to national unrest about racial issues, Fairfax County School Board redesigned its admissions process. It scrapped the standardized test that had been an admissions tool in prior years and switched to allocating most seats to students who were in the top 1.5% of their Fairfax County middle schools. Because Asian American students are disproportionately concentrated in particular Fairfax County middle schools, these changes had the purpose and had the effect of decreasing these numbers of Asian American students at TJ. It was very clear from the record produced in litigation that the board's overriding concern was race. They talked in private text messages about their racial goals. They talked on the record in public meetings, enacting resolutions that they wanted to change the racial demographics of the school. They sought data showing the likely racial effects of different alternatives to see which one was the most likely to get them the racial results they wanted. I disagree with any characterization of this plan that this was somehow race neutral, that this was driven by a desire to increase socioeconomic diversity without regard for race. The record below strongly suggests that the board's overriding goal was racial. As the district court judge observed at one point during the litigation, everyone knows this isn't race neutral. You can say all kinds of beautiful things while doing others. Unfortunately, we lost again in the Fourth Circuit and then petitioned the Supreme Court for certiorari. The court declined to take up the case, but it did draw a scathing dissent of denial from certiorari from Justice Alito. As Judge Menasche alluded to a few minutes ago, that he suggested strongly that this case the Fourth Circuit's opinion below could serve as a blueprint for evading students for fair admissions. That's highly unfortunate, and I hope that that doesn't happen, though the early evidence suggests that it will. Two other Pacific Legal Foundation cases in this area. Second, Boston Parent Coalition versus Boston School Committee. Like Fairfax County, Boston also has selective public high schools. In fact, 3 of them, most famous of which is Boston Latin, with a history going back to the 18th century and a veritable who's who list of famous alumni. Boston was also unhappy with the racial demographics of its schools, so it re-engineered the admissions process to get the results that it wanted. It used a system of zip code quotas, again because Asian American and white students tend to live in particular zip codes. As with TJ, the new process got the Boston School Committee the racial results it wanted. Once again, some strong evidence of racial intent here. 2 board members were even caught in a hot mic making fun of Asian Americans' last names and were forced to resign, along with the chairman of the board. That case, as was alluded to a few minutes ago, is also pending certiorari in the Supreme Court. One more Pacific Legal Foundation case involving New York City's magnet schools. There, most slots at New York City's magnet schools are handed out by exam results, but a small number are handed out through what's called the Discovery Program, which allows a few students from high poverty schools to get in despite scoring just under the test cutoff. A few years back, New York City re-engineered the system so that students from schools that just happened to be disproportionately Asian American were no longer eligible for the Discovery Program. This had the purpose and this had the effect of changing New York City's magnet schools. So are universities going to copy this? Well, just days after Students for Fair Admissions, law school admissions office officials on video said that the Coalition for TJ decision could serve as a blueprint for how universities could evade Students for Fair Admissions and get the racial numbers they wanted. This isn't right legally. The old cases that I talked about a few minutes ago show that the Constitution doesn't allow the use of proxies to engineer the racial results you want in other contexts. This context isn't and shouldn't be different. At the end of the day, if you're an Asian American kid getting shut out of your dream school because of the color of your skin, it shouldn't matter whether it's because of an explicit racial preference or because your school adopted some Rube Goldberg scheme to get the same result as if it had used explicit racial preferences. I hope the Supreme Court takes one of these cases to make clear this important legal and moral principle and stomps out discrimination by proxy. Thank you.
Thanks very much. So just to clarify, so Professor Kallenberg a moment ago described the TJ admissions policy as a genuine racial alternative, but your argument is that it's not genuine, right? Your argument
Correct.
depends on the record showing that they adopted these criteria with the intent to discriminate.
That's correct.
But if TJ had adopted the same policy, but there was no such evidence that they intended to discriminate, or maybe even that, you know, the racial composition was geographically distributed in a different way, that would be okay, right?
So I think that if TJ had adopted a similar policy with a different purpose, if there were evidence that it was truly concerned with socioeconomic diversity, with geographic diversity or something else, then that policy would well be lawful. It's true that Arlington Heights, which is the leading case in this area, it involves a flexible balancing test. There are many factors, and so there's some play in the joints about how they're applied. But I think that in this case, there's strong enough racial evidence to make it clear that the board was motivated by race and not by some other race-neutral purpose.
So schools, if they wanted to do geographic criteria or socioeconomic criteria, they could do that, but they have to let the racial chips fall where they may, I guess, would be your position.
That's a fair characterization, yes.
Okay, I'm going to ask the panelists to respond to each other, but in the meantime, if anybody has questions, why don't you line up at the microphone so we can move seamlessly from that discussion to questions. But before we do that, maybe I'll just go down the line and see if you have reactions or questions for your co-panelists.
Yeah, I was just going to say one thing, which is I don't think I agree, but if Harvard accomplished nothing but moving universities, you know, it didn't change any numbers, but it moved universities toward treating applicants as individuals instead of as products of their skin color, that's not nothing. I think that's a big improvement in the law and for our country.
I would suggest that I think it's really important in this context in particular to remember that the reason that affirmative action was adopted in the first place was because universities and corporations and institutions denied access to Black Americans for 150 years. So affirmative action was originally adopted to try to level a playing field that had been slanted against Black Americans and Brown Americans for most of this country's history. And so what we're talking about here when we talk about affirmative action today, now, 50 years after Bakke, is now we may be talking about racial balancing, now we may be talking about diversity or race proxy, but at the end of the day, the law inartfully was trying to remedy a discrimination that had been visited upon Black Americans for the extent of their presence here in the United States. And so I've always been mystified by how excitable we get over what has been a very minor piece of the admissions programs at universities and law schools across the United States. Legacy admissions are much more significant, much more substantial. I don't see the same outrage in connection with legacy admissions. preferences, and it's something that I think is important to keep in mind, that as we grapple today in 2024 with how to deal properly with diversity and affirmative action, that the roots of the principle were based on remedying just harmful, hateful discrimination.
So a couple of things. One is I'm really angry about legacy preferences, and edited a book on legacy preferences. This was a major plank in the Students for Fair Admissions case against Harvard, saying, well, if Harvard was claiming the only way to get racial diversity was to use racial preferences, and yet they have this system of providing a leg up disproportionately to white and wealthy applicants. So, some tension there at the very least. But I want to focus mostly on my difference of opinion with Allison. So the argument is made that if racial diversity is part of the purpose of let's say, Governor Bush's top 10% plan in Texas, that makes it just as bad as racial preferences. It's basically the same thing. And curiously, this argument came up not from the right, but from the left in the Fisher case. So it was Justice Ginsburg who said that the top 10% plan was essentially equivalent to racial preferences. And I think that misses really, really significant differences. The first, obviously, is that a racial preference only benefits certain racial groups. Asian American and white students who went to high schools that had very few students going to UT Austin that may have been less competitive also benefited from the top 10% plan. There's no racial stigma associated with socioeconomic preferences or a percentage plan. The Brown economist, Glenn Lowry, who is African American, says, knowing that I'm being judged by standards that are different and less rigorous, by virtue of the fact that my ancestors suffered some indignity, is itself undignified. A percentage plan doesn't do that. The students who get in can feel completely proud of the fact that they competed hard and gotten the top 10% of their plan. That's not a racial preference. The percentage plan does not feed racial animosity the way that racial preferences can. In fact, in Texas, you saw conservative white state legislators align themselves with Black and Hispanic urban state legislators to push for the top 10% plan, because the UT Austin wanted to just admit students who would make them look better in the U.S. News and World Report, the top SAT scores, the rich kids. And you had this beautiful coalition of people who never worked with each other, people who had racial antagonism, working side by side for the top 10% plan. So there are gargantuan differences in practice between racial preferences and race-neutral alternatives that are aimed in part for racial diversity.
I share Dean Cummings and Professor and Richard's comments about legacy admission. It does seem a bit inconsistent that there's an attack on some preferences, but not all preferences, and especially when we know that legacy admissions would disproportionately disadvantage minorities. And so it's a sort of interesting perspective for me. The other challenge that I have, again, and I'm just going to voice this again, which is that this assumption that the amount of diversity should decline based upon this case. And I'm just really struggling to figure out why some individuals hold that as an end, that because of this SFFA case, the amount of diversity should decrease. Again, I think back to, you have two students, one student grew up in a privileged environment. Their parents the student had affluent parents who could provide, a host of opportunities in bar prep and study prep and SAT prep for the student, and the student gets a 1400 LSAT and has a 4.0 GPA. And then you have another young person. The young person was sexually abused at the time that they were 5 by their father left, so the child was with their mother. The mother was on drugs and would sell the little boy to the drug dealer up the street for sexual favors in exchange for drugs so she could get high. The little boy then gets taken from our mother and moves in with someone else. And when the little boy moves in there, the little boy is sexually assaulted again by an older brother figure. The little boy ends up in jail because he abused his younger brother, and ultimately gets into college and ultimately applies. They're at the same point, they're applying for whether it's law school or undergrad, and the young person has a 1200 SAT score and a 2.5 GPA. If I'm making a decision and I decide to admit the second person that I mentioned to you because their story was more compelling, does that mean that the other person didn't get in because of the fact that of their status as, let's say, a privileged, let's assume that the person is a white male. Does that mean that they didn't get in because they were a white male? I think that the story itself is a preference that adds value that we can place strong emphasis on according to what Justice Roberts said in his opinion. And interestingly, the story that I did describe to you, the second story, is a true story, and it was actually involving a young white male. And I thought it was a compelling story. Those stories transcend regardless of whether you're black, you're white, you're Hispanic, you're male or female. And I think that just paying attention to the value that people can add is really important. And I don't walk into a situation presupposing that the statistics have to stack up a particular way. And if people do have that, I'm really curious about where that idea originates and what are those numbers supposed to look like. Because obviously there's an assumption of what they should be, and there is nothing in Justice Roberts' opinion that dictates that the numbers should change.
Okay, Allison.
Thank you. To respond to Dean Clark, I have no objection to universities or selective high schools using holistic system of admission, using essays, personal stories to determine who attends. I think that different universities can make different choices in that regard, so long as their purpose isn't racial, so long as these essays or holistic methods aren't being used to put a thumb on the scale for one particular group. Mr. Kallenberg spoke a few moments ago about the top 10% plan. My understanding is that there were a range of different reasons why the plan was adopted. In the Fisher case, the record wasn't really examined in detail because Ms. Fisher was only challenging one particular part of the admissions scheme in Texas. She was challenging the use of holistic review after a number of seats had already been allocated by the top 10% plan. She wasn't challenging the plan itself. If some kind of percentage plan is adopted for racial reasons, I think that calls into question its constitutionality. I think it's every bit as stigmatizing to be admitted through something like a percentage plan if you know or suspect that this plan was adopted for racial reasons to engineer a racial outcome. Putting a thumb on the scale is the same thing as if preferences are being handed out at the retail and individual level.
Thanks very much.
Allison, a question about that?
Well,
Never
I want to start taking questions from the audience, so why
yeah,
don't we start with that, and then we'll come back. Take the first question.
Thanks to the panel. 2 quick points and a question. Number one, there was an error in stating the results of the MIT recent class. Racial minority enrollment did not go down. It's just that it was the wrong minority. They increased the enrollment of Asians dramatically and slightly decreased the enrollment of whites. And I have to say that listening to this entire discussion, I find it saturated with racial animus against Asians. Very similarly against Jews, these groups also suffered a great deal of discrimination, and the fact that they overcame it with excellence is being reviled. Number two, to Dean Clark, of course, SFFA should result in a better class and more diversity at the University of Delaware, because ideally, you're going to pull out a few of those top black students that are now being forced into Harvard and Yale. And the question is this: for those who are so intent on supporting diversity in its own sake, including racial diversity, what do you say about the extensive research that has been conducted about mismatch in the schools? That's what it comes down to. Who's competitive in the class? And what is the point of bringing in people that are always going to be at the bottom of the class? There has been research finding that someone is much more, if they go to a class where they're properly placed, a school where they're properly placed, they're much more likely to pursue a STEM career than if they're forced into a top school like a Harvard or an MIT where they are not competitive. They're more likely to drop out. Thank you for listening.
Somebody want to address the mismatch? But yeah, why don't you go ahead?
Yes. So I think that's a beautiful question. Richard Sanders' theory, I think his theory itself is mismatched. I think it's a trash theory. I think it's inaccurate. And to me, what it reflects is a poor teacher. One of the things that I aspire to do, when I call myself an educator and a professor of law, I inspire my students. When they walk out of that classroom, they can accomplish anything in the world. And I believe that my students are the best and brightest in the country because I elevate the status of that classroom. And I think sometimes that mismatch theory is used because you have poor teachers that have an inability to inspire and educate. And that's what our responsibility is. When the governor of Virginia talked about just the educational system and the issues that they were having in Virginia, a lot of that comes down in making sure that you don't handcuff good professors and you allow them to operate in the classroom and inspire students. So I think that is a poor theory. I don't subscribe to it. I think Dean Cummings, you actually wrote an article or a response to that, so I know that he's chomping at the bit over here.
Respond, but you're
Okay,
doing
I'm
it.
done.
I think we have the response. So why don't we take another question?
Yeah, hi. So my question revolves around what is the future of this type of litigation? Like, just to throw out an example, like major questions doctrine, you can kind of see that building through the years to get to a certain point. After this, after getting rid of racial preferences, I mean, apart from teething issues, and I mean, obviously we're talking about people cheating, is there really anywhere else to go, or is this bedrock? Because when I think about it, like, MIT being dissatisfied with, their most recent class, that just kind of seems like a laziness in the admissions department issue, right? Like, I mean, like you guys can't figure out how to get the people you want here without having a box saying who's what, I mean, that's pretty
So
lame.
I think we get that. So we've already heard from Allison about proxy discrimination, but I know that you are litigating the cases at the military academies, which might be different. So that is something else that's going to be decided, and maybe you could talk a little bit about that and anything else on the horizon.
Yeah, so SFFA, the plaintiff in Harvard, has filed cases against West Point and the Naval Academy because the Supreme Court left that question open. So those need to be decided. But I mean, fortunately, there are not a lot of places left in American law where you're allowed to explicitly use race. College admissions was one of the last. I think it was down to college admissions and to quell prison race riots are like the two that have been recognized. And now there's just prison race riots. So if there are uses of race in the employment sector, the private sector, our view is that those were illegal before Harvard because college admissions was one of the last places. So there is litigation going on about the sort of vestiges of racial preferences. You've got the military academies, and then, hopefully everyone complies, and if the numbers don't change, and that could be perfectly legal and fine. If they do change, what to look at that, and I think there could be, there had to be enforcement litigation after Brown. There could be enforcement litigation here, but we don't have enough information yet. But I will say, if schools are out there thinking, we can get around the Harvard decision this way, or we should do this to achieve the same result, but not say that's what we're doing, please write that down and put that in emails and other documents that can be found in discovery later.
I'll just add really quickly,
Okay.
Judge. I heard the word lazy, and that has come into my mind repeatedly. And I think it's important for everyone here in the room to understand that my admissions committee and my admissions team is not lazy. They comb through and they read personal statements. I read personal statements. I we are looking for diversity writ large globally. And I just want to mention two really quick things. One is that I have written articles contesting mismatch theory, and I believe it's deeply empirically unsound. The last thing I'll say is I view Asian American diversity as a huge part of what we want to attract to our law school. You know, if there is a student that has overcome difficulty in their life based on racial discrimination, based on their Asian ethnicity, I want them at my law school, and we encourage Asian American diversity within the confines now of SFFA to apply and become members of our seated classes. So I'll stop there.
All right, before going to the question, can I just clarify? I got the 5-minute signal, but the program says 3:15. Are we ending at 3? Right. Okay, so we have some more time for questions. All right, let's take the next one.
Thank you so much to the panel. So I sense here that the audience and the panel are all paying homage in a way to the theoretical ideal of diversity, especially for the intellectual benefits. And I think we all, to some degree, believe there are those benefits in an ideal world. The problem that I want to suggest, though, is there's an elephant in the room we haven't discussed, which maybe completely reframes how we should look at this. And I want to ask particularly the academics on the panel whether you run into this and how you handle it and what the larger implications are. The fact is, during my lifetime, since kindergarten, maybe 25 years ago, there's a really disturbing trend. In racially, ethnically, gender diverse situations in school at every level, what I sense is the goal of the administrators and most of the students, it's not an intellectual discussion, it's to make the white straight men feel bad. You know, that's what it ends up amounting to in effect. Intellectual diversity doesn't happen. Instead, you have a sort of choreographed debate where some people's views and lived experiences are more valued than others, and this is indoctrinated. I mean, I'm talking about critical race theory here, right? Basically, that's what it's culminated in the last few years. So I fear, especially when I started hearing about certain minority groups actually wanting segregated dorms, wanting segregated groups, you know, a return to that sort of mentality, and God knows maybe some whites feel that way sometimes now. Are we actually, so what I want to ask you is, are we actually in a place in our society where we can even accrue the imagine the hope for benefits of diversity, or are we actually facing a much larger problem, which this court case leaves us, you know, having to handle?
Someone want to tackle that?
I'll just say one thing. I mean, it seems to me part of what you're talking about when you mention critical race theory and a certain worldview is that you're looking for ideological diversity. And I think one of the big benefits of the Students for Fair Admissions decision is that some institutions are changing the way they admit students and will become more socioeconomically diverse, which in America translates into ideological diversity. I mean, the biggest divide now ideologically is the diploma divide. So you have students who come from first-generation college backgrounds who haven't already been indoctrinated into a certain worldview that you find at more polished suburbs and private schools. And so I think one of the big side benefits, or unrecognized side benefits, of the fact that, you know, for example, Yale said that they just admitted the most socioeconomically diverse class. I think you're, to the extent that they're bringing in students of all different races who are socioeconomically diverse, that will bring in, you know, lest I say, J.D. Vance's and others who will make the discussion more interesting and more robust. As someone on the center left, when I was at Harvard, I got no real intellectual challenge because everyone just agreed. And I thought the conservatives got the best education on campus because they were constantly challenged. And I agree with you that the ideological diversity will benefit everyone.
You know, the scenario that you've described, I've never seen that in my class, and I've taught for quite some time. So I would imagine that if you reached out to my students, they probably agree. I don't know that you'd find anyone that believed that I engaged in white male bashing in the class. I think it's important to facilitate honest discussion, and I'll give you by way of example. After in our Dean Cummings and I, our corporate justice book, we talk a lot about the financial crisis. And one of the things about the financial crisis, there were a lot of banks that engaged in predatory lending of marginalized and black and brown borrowers. And what we did in that book is we took a peek at the board of directors for those companies that were some of the primary culprits of the financial crisis, AIG and Bear Stearns. And when we looked at their boards had little to no diversity, none. If I remember correctly, Bear Stearns had 0. There were 9 men. And then AIG may have had a woman, and they may have had one other person of color. And so in my classroom, I facilitated discussion, would diversity have mattered? And we have a discussion about whether it would or wouldn't have. If you added more diversity, would that have impacted the discussion? And the students are really engaged in the discourse, and it's never about bashing a particular group. It's more about, should our boards reflect more diversity? And if so, does it matter? We look at the data. Are diverse boards more profitable? And I tell them, some of the data is inconclusive on that. There's a really cool article from Dobbins and Jung that talk about how diversity can, in fact, impact market price, not necessarily profitability, but some really interesting work. And that's the type of discussion that I would facilitate in my classroom and that I encourage at my law school, not a bashing, because I care for all of my students. And you want your students, regardless of whether they're white, black, Asian, male, female, to walk into a learning environment where they feel that they belong. And if you think about the institutional mantra of Widener University, if you can ask Dean Cummings, our president, the key word is belonging. So I would never want any of my students to feel as you just described.
I really wish I'd had your class, sir. Thank you.
I believe a few of you were talking about preferences based on socioeconomic status. I think some people mentioned Appalachian preferences or preferences based on a traumatic backstory, like that child who unfortunately was sexually trafficked. Are any of you worried that preferences like that create a fight of the top and the bottom against the middle?
No. I mean, I advocate a kind of a sliding scale of socioeconomic disadvantage. One of the interesting facts that came out in the Harvard litigation is that they tagged students as disadvantaged, and it was 18%. And I thought, well, what do they mean by disadvantaged exactly? And it turns out it was basically the bottom two-thirds of the socioeconomic distribution. So when many of us might think of a disadvantaged student as someone who went to a really high poverty school, came from low income or working class background, no. This is, the institutions are so incredibly wealthy in their student bodies that being in the bottom two-thirds made you disadvantaged. And so I think a socioeconomic preference actually would result in more middle class and low income and working class students, not just students in poverty then along with wealthy students.
Thank you.
Okay.
I will tell you what I do worry about is AI writing personal statements for students, and someone prompting AI to say, give me a boot up by the bootstrap story, write it. So we have to be not lazy in our admissions offices and pay attention to how we're trying to prize diversity writ large.
So how do you verify the authenticity of an essay?
We're working on it. Yeah, we rely on other AI.
So actually, that's an interesting question. I mean, we're talking about these holistic reviews. Are the admissions practices changing? Do you ask for extra essays? Do you have more personal interviews? Is there something else that you're doing in the model that you're describing?
So one of the things that you're seeing in some of the admissions offices, they're hiring readers. So that's one of the things that we're doing is we're bringing in experienced readers to help us process through the applications. I think that's one component of it. Obviously, we are putting in just more time to get through all of those essays. So the things that you mentioned are some of the things that we are doing now so that we can thoroughly evaluate each of the applicants.
We just instituted a pathway program where we have stellar LSAT instructors that take students that apply from all socioeconomic levels and races through a 12-week LSAT preparation program. So what we're trying to do is lift folks that have been historically discriminated against or shut out over the barrier that the LSAT creates into law school. And so it's open to all students, all races, but we're specifically in central Pennsylvania, where we have a lot of first-generation students, a lot of communities of color that have been discriminated against, and we're putting them through a pathway program to help elevate their LSAT profile so that they can enter law school, hopefully ours, but we've had a lot of success with students getting into a lot of really great law schools across the country just based on paying attention to helping students make those inroads.
Go ahead.
All right. Thank you for the panel, everyone. Try to get through this question pretty quickly. Some of the things that I think has been an emerging theme in the conversation from the panel is around the concept of proxy for race. And wholly agree that universities should not be able to take an arbitrary facet about a group and then assume because that person's part of that group that it is therefore a proxy or that they belong in that diversity set. However, it's been advanced by the majority of the panel that somewhat proof of the effectiveness of adherence to the law will also reveal in a change of demographics in the school, which in some interpretation could be seen as a proxy for race. So if I'm essentially asking for the panel to define the limits of what is a proxy and what isn't a proxy, and to follow up, does anyone on the panel believe that schools should not have to report on their racial demographics? And if they do, and if none of you believe that schools shouldn't, I would love to know why.
Okay, since Allison introduced the idea of proxy, why don't you address what is and isn't a proxy, and then we'll probably have a response to that.
Okay, so I mean, the basic idea is is the trait being used to achieve a racial result? I agree there's some ambiguity, and the question becomes how closely does the trait match race? How closely does use of the proxy allow the school to generate a racial result? The more closely aligned the other trait is with race, the more likely it is that you're using proxy discrimination and that you're doing something that's prohibited by the law.
Anyone else want to say something?
I'll just say, I thought that that Cam's counterpart, Patrick Strawbridge, in the University of North Carolina case, gave the right answer when the Supreme Justice asked him, well, now you're going after race, or you're just going to go after proxies next? And his answer was that if the only reason that an institution was employing a certain factor was that it had a certain racial result, and there was no other independent rationale. You couldn't think of some other reason for why you were doing this except that you wanted to get that racial result, that would be, in his phrase, the only place where that would be a problem. And I thought that was a compelling answer.
That's different from how we normally enforce anti-discrimination mandates, though, right? We usually say that if race is a motivating factor, even if there were other motivating factors, it's still discriminatory. So
right, and that gets,
you're advocating
yeah,
a kind of different rule in this context.
I am, and it's because the purpose is different. The purpose is not invidious discrimination. The purpose is to integrate an institution of higher education. Now, with respect to using race per se, of course, the Supreme Court has said in the parents involved case, no dice. But I think there's a space between racial diversity being a compelling purpose and an impermissible purpose. I think there's space for something in between, and Who knows, but my guess is that's where the Supreme Court will land.
And I like the question because it really harkens back to what I wanted to ask Allison earlier, because I think she did a wonderful job of explaining when she mentioned the 3 cases. And in each of those cases where she talked about a proxy, these were all evidentiary questions is what they were. Because if I remember correctly, Allison, you talked about how and in one of the cases, there were specific text messages or communications that were exchanged. And those communications, I think, were very compelling in suggesting that it was a proxy. So from my vantage point moving forward, if there is an attack, I don't think it's just the end results itself. And typically what you see in discrimination, statistics could be used to indicate maybe some sort of presumption, although it's rebuttable. But what you typically are going to need is that evidence, that smoking gun evidence. And I think that in the cases that you highlighted, that was one of the consistencies that ran through those cases. So I think that's what you would see, and that's how you would be able to identify that real proxy where the dean or the person in admission says, I want 10% of our class to be this, and we're going to do whatever we can to get there. And you got conversations between the admissions officer and the dean that are having that, and you have that evidence that you could utilize.
Yeah, can I add something?
Yeah, go ahead.
None of us is rooting for or wants to see a change in the racial diversity numbers at any school. Like the problem is this: we had very sophisticated race-neutral alternatives that got Harvard, to the similar place racially, but they required, substantial socioeconomic preferences, and it required eliminating legacy preferences. The problem is not with the numbers; it's with numbers that don't move and universities that don't change their admissions policies, other than stopping the use of race. That's where you might start to be suspicious. But there are race-neutral alternatives that would work and would not require elite universities to change their racial numbers. But the other thing to keep in mind is, it's not us. We didn't say the racial numbers would change dramatically if they stopped using race. Every elite university filed a brief in Harvard saying, we have to use explicit racial preferences or our racial minority numbers will plummet, and we cannot save them with race-neutral alternatives. It's literally impossible. So, maybe the takeaway is that they all lied to the Supreme Court, but that's what sort of raises the potential concern, which again, we don't even know if it's a concern yet.
Cameron, if diversity numbers, racial diversity numbers increase 10%, and assuming there's no gaming in the system, you would be very happy.
Yeah, I agree with you, especially with how you describe the law. Disparate impact has never been a constitutional violation or a Title VI violation that private plaintiffs can enforce. So that's not enough evidence. It's not the numbers.
Mm-hmm.
You would need to see some other indicia.
Okay.
All right, we're in the last couple of minutes, so why don't we take one last question?
This is largely for Mr. Norris. So, in the Solicitor General's brief in SFFA versus West Point, they discuss phenotypical advantages within the military context in particular, such as creating better cohesion and performance on the battlefield. And they also pointed out that alternatives were difficult to implement due to the way the nomination process works at military academies. So obviously, Justice Roberts said that race qua race was unconstitutional, and it's impossible to measure. But if there is shown to be some kind of phenotypical advantage, in certain circumstances, why would that fail the SFFA versus Harvard or UNC standards?
Yeah, I should probably not speak to this. We have a trial that starts on this issue next week, so we'll see what the evidence bears out and what the arguments and how they work or don't work in court. But one thing I will note is there's a footnote 4 of the Harvard opinion that says we're not addressing the military academies. That did not say that the military academies can use race. It just said it's an open question, so it could go either way. It was not a blessing. I think it just means that it has to be litigated. We've in the case compared that to the fact that United States versus Windsor said that the Supreme Court is invalidating the federal definition of marriage that excluded same-sex couples, but it did not decide the validity of state bans on same-sex marriage. Then Obergefell came, it was litigated, and the court said, well, actually, under Windsor, that's unconstitutional as well. And so that's an example of how it could go either way. I think it's just an open question.
Okay, great. So with that, please join me in thanking our panel.
Thank you. I enjoyed it as well.
Thanks again, everyone, and we will have one more 15-minute break and then meet back in this room at 3:30 for our last plenary session of the day.